are going to continue with this court. Most likely, we're going to take it up from there because the court, by virtue of what transpired today, I don't think we still have implicit confidence in the ability of the court to deliver justice in this case.
Yeah. If I could just interject, could I apologize here? I say my name is Bruce Fine. I'm Nnamdi Kanu's international lawyer. I'm from the United States. Today was the 5th time I was told I could not enter the courtroom, despite the court's previous order that Nnamdi could have access to any 3 persons he wanted to. I actually had a chance to talk briefly to him on the way to the courtroom. It's clear 5 times that they are targeting me in particular. That's the reason why this proceeding did not transpire today. And I'm here to tell the Nigerians and the international community, I'm taking this now to international tribunals. It's clear that the Nigerian tribunals are compromised.
What will happen?
Nigeria for gross violations of fundamental human rights. And there's no more fundamental right than a right to access to lawyers in a criminal case. It's enshrined in the Nigerian Constitution. It's enshrined in the International Covenant on Civil and Political Rights. It's enshrined in the Universal Declaration of Human Rights. It's a basic principle of civilization. If you're accused of a crime, you have a right to counsel. And he's been denied access to me 5 times. And I'm here not to be an irritant. There are huge international law issues that are present in Nnamdi Kanu's case. You all know this kidnapping in Kenya, the extraordinary rendition to Nigeria just being one of them. So I'm here because I'm an international law expert to provide more enlightenment on what legal issues are present here. I'm not here to just try to create a problem or to create some kind of irritation.
Today prepared for the application to go on. So of course we'll have some challenges because that has been the practice in this court. Each time this matter is coming up, you will see a situation whereby lawyers are being restricted from getting access to the court. So, and today we insisted on resolving it. Our bags, our wig and gown, our books are inside the court. And we are just outside the court to resolve some of these issues. Because DSS, the prosecution in this case, determined they want to tell us the number of people who are going to come. They insisted that we cannot be more than 5% that will have access to the court. And I said no. We have more than 8 lawyers from the Attorney General office who are inside the court. We have more than 8 members of SSS who are officers of SSS who are inside the court. I wonder why only 7 of us who are here to get access to the court, they refuse us access. So we are trying to resolve that issue outside the court before the court came in. Now, ordinarily, when the court rise, the court should have called the attention of the legal counsel, knowing fully well that we have our books, our bags, our wig and gown, we're inside the court. We have called attention to find out what actually is going on and possibly see how to resolve it. So last adjourned date, we have a similar situation. And I mentioned to the court that look at the challenges we're having. We have over 50 lawyers locked outside. We have lawyers who also managed to come up. They were not allowed access to the court. So they are not much in their numbers. The court will have access. Let's seek clarification from us before proceeding. But I'm not surprised. We are still outside. When we are told that the court was about to sit, we are trying to get inside. They lock us out. They lock us out. I was insisting, shouting that they should open the door. They lock us out. So we didn't have access to court, only for us to be told that the matter has been mentioned and adjourned to 19th and 2nd of January 2022. Recall that we have an application before this court challenging the competence of the charge. 1, 2, challenging the use of the court to proceed with it. Because what we have before the court is just an empty paper before the court. There's no paper, there's no offense before the court. However, last adjourned date, the court reviewed the guideline as to the person that will be visiting him, present where he didn't return. The guideline now accommodated 3 persons of his own choice, not 3 persons that will be determined by the authority or detention authority. No, it's 3 persons of his own choice. That order was roundly flouted by the DSS. And we have on 48 before the court now to commit the head of the agency for contempt of the court. We have an application also before the court, which also is predicated on imagined facts, that for him to be transferred to a place we have access to him, to prepare for the case, and also discuss this matter with him. We can't be visiting him under the atmosphere of fear. We can't be visiting him where they will decide to obey, to choose order to obey and don't want to obey. So these are situations we find ourselves at stand now. So where as team of lawyers are going back, we are going back to strategize and have an understanding as to what to do next. Because we know that we are going to take it up and we ensure that this matter is hard before this end of this month. I can assure you of that, because we can't give in to that kind of that kind of travesty of justice. We can't give in to that. Thank you so much. And they might recall that he's still in detention. And Agja is specific on the guideline for trial of person who is in detention. And he said day-by-day trial. That's what the law says. So if you understand, you circumspect of the fact that the law says day-by-day trial, and taking into account the nature of the matter beforehand, the judge will have also given us a short date for us to come back and commence the trial, even if it's not mindful of hearing an application. Or even hear application when we deem it adopted before the court. Because the law allows him to also adopt the application before him, because it should have been done. So that's what we're going to go back and strategize and come back and also and do the needful. Thank you so much.
Yes. And one thing, it's very clear to me, they shut down. When I'm not there, everything goes smoothly. So it's very clear they're singling out me, trying to punish anybody who has any association with me. I'm his international lawyer. I'm his international spokesman. He has a right under international law and under the Nigerian constitution to retain anyone he wishes to represent his interests in criminal proceedings. That is being flouted. And there's one thing that I have already decided as Nnamdi's international lawyer. We don't need any strategy. I'm going to the working group on arbitrary detention in Geneva, go to the International Criminal Court and the International Court of Justice in The Hague, the U.S. Congress, to bring to light the travesty of justice that is occurring. That right now, Nnamdi is being detained illegally. He's being charged with actions that aren't even crimes. He hasn't even had any due process yet. And here it was in June. Now they're going to be in January. That's punishment before trial, right? No trial, he's already being punished, held in solitary confinement without access to medical care. Those are egregious violations of fundamental human rights, and the international community now will look at Nigeria with suspicion, and Nigeria can expect sanctions unless this changes very, very rapidly.